Okay, we're going to call the State Charter Board to order here. What we have today, members, is, well, I guess first we need to do roll call. Bianca, you want to call the roll?
President Logan?
Here.
Vice President Bedanson?
Here.
Superintendent Designee Morley?
Here.
Ms. Alvarado Hernandez?
Here.
Mr. Anderson?
Here.
Mr. Butler?
Here.
Ms. Day? Mr. Ironman?
Here.
Mr. Jenkins? Mr. Jewell?
Here.
Ms. Sensman?
Here.
You have a quorum?
Excellent. Board members, if you remember our last meeting, we had a little bit of a discussion, and there's been a discussion in the sort of charter community about procurement exemptions, and so what we decided to do was have a study session today for really with two purposes, and you can see them both in the agenda. One is a discussion by staff of sort of the history and where it originated from, and then two is to do a call to the public, so folks wishing to speak on the issue had a chance to address the board, and then any conversation we want to have beyond that. So with that, Deanna, it's your show. Item A.
Alrighty, Mr. President and members, good afternoon. Thanks for joining us today. You basically have outlined the process that we'd like to take today. I think we'd like to start with Andrea giving you the history and the background. I had the opportunity to speak with a number of the charter representatives on this matter and have some comments of theirs to share with you. And then after we provide you with that information, you may choose to have some discussion at that point in time, and then additionally have get some call to the public as well. At this point in time, we have one call to the public form submitted. There are other forms available, and would encourage anybody who wants to participate to submit one of those forms to us. So if we are good to go in that direction, then I will turn it over to Andrea.
President Logan, members of the board, today I will address certain statutory provisions, the board's current exception process, information disclosed through the annual charter school audits, and the board's current audit-related policies and practices. Under the charter law, the board may contract with a public body, private person, or private organization for the purpose of establishing a charter school. As of November 2012, the board has 393 active charter contracts. Approximately 91% of the board's current contracts are with nonprofit entities. Approximately 8% are with for-profit entities, while government entities can make up the roughly 1% that's remaining. Although specifically not tracked, it is believed that many of the nonprofits that the board contracts with have received 501c3 tax-exempt status from the Internal Revenue Service. This slide includes information regarding certain characteristics of your portfolio of schools and charter holders. This information may be useful as you explore whether changes should be made to current board policies and practices. Based on fiscal year 2012 attendance data, nearly half of the board's charter schools have an average daily membership, or ADM, of less than 150, while less than 10% have ADMs of more than 600. As you know, schools' ADM drives the state equalization assistance received by the charter holder. Since today's study session focuses on charter school procurement, the second bullet on this slide includes a range for the amount of money spent by charter holders in fiscal year 2012. Staff pulled the amounts from the fiscal year 2012 audits based on the ADM information above. The low end of the range reflects the expenses for the smallest charter school site operated by a single site charter holder. The upper end of the range reflects the expenses for the charter holder operating the largest school site. In this particular case, all of these expenses are directly related to charter school operations. Finally, as of November 27th, the board has granted procurement exceptions to nearly 90% of its active charter holders. The charter law allows charter schools to enter into contracts. This would include contracts for facilities and individual services such as special education or custodial services, but could also include contracting with an education service provider, or ESP, to provide comprehensive services addressing most or all aspects of a charter school's operations. The major types of charter school ESPs include charter management organizations, education management organizations, and comprehensive school design providers. For the most recent 4 cycles, the board's new application process has required applicants to disclose whether they intend to contract or have a governance relationship with an ESP, and if they do, to submit specific information as part of their application packages. For applicants that intend to contract or have a governance relationship with an ESP, the submitted information may be found in section B.3.1 of the organization plan section of the portfolio provided to the board when it considers the new application. Further, ESP status is also addressed in the replication application process. The board's procurement compliance questionnaire includes certain requirements related to charter school procurement and reimbursement. Statute, administrative rule, and the Uniform System of Financial Records for Charter Schools, or USFRCS, serve as the source for these requirements. ARS 15-213 requires the State Board of Education to adopt rules prescribing procurement practices for school districts. The current version of the school district procurement rules is 68 pages long. It is my understanding that representatives from the State Board of Education, Attorney General's Office, Auditor General's Office, and school districts have been meeting on a comprehensive revision to these rules. ARS 15-213 also requires a systematic review of purchasing practices for school districts, non-exempt charter schools, and school purchasing cooperatives. The systematic review of purchasing practices has been highlighted in the copy of the board's questionnaire linked to this presentation. Since your computers are not connected to the internet, a copy of the questionnaire has been included in the folder containing the study session materials. The systematic review comprises 6 numbered questions that include 39 parts and subparts. The remaining questions in the board's procurement questionnaire, those that are not highlighted, address requirements found in the USFRCS, including those pertaining to oral and written price quotes. The current charter thresholds for oral quotes, written quotes, and competitive sealed bids and proposals have also been included on this slide. The charter law subjects charter schools to the same financial and electronic data submission requirements as a school district, including procurement rules. However, from the beginning, the charter law has also allowed a charter school sponsor to grant an exception to the procurement rules found in ARS 15-213, as well as to the USFRCS. In 1996, the charter law was amended to exempt the charter school's procurement from public bidding requirements if the aggregate amount did not exceed the maximum exception amount authorized by the state procurement code, which is $50,000. This law further allowed the board to authorize an exception from public bidding requirements that exceeds the maximum exception authorized by the state procurement code. While currently the competitive sealed bid threshold is the same for both school districts and charter schools, it is my understanding that that was not always the case, and for a period of time, the competitive sealed bid threshold for school districts was lower than $50,000. So for those charter holders subject to the procurement rules during that period, ARS 15189.02 allowed them to use quotes for purchases up to $50,000 instead of following the requirements applicable to school districts. The board has historically included exemptions to the requirements of both ARS 15-213 and ARS 15189.02 in its approval of exceptions. Under an exception, the charter holder is no longer subject to state procurement regulations. However, federal procurement requirements would still apply. Once granted, the procurement exception becomes part of the charter contract. Therefore, the board is unable to unilaterally rescind an exception since changes to the charter contract must be agreed to by both parties. It, however, may be possible to rescind the procurement exception as part of a settlement or consent agreement that results following noncompliance on the part of the charter holder. As was mentioned earlier, the board has granted procurement exceptions to nearly 90% of its active charter holders, and at its November 26th meeting, the board tabled 4 procurement exception requests. This slide and the next highlight certain procurement exception-related discussions and actions that have occurred since the board was created. I don't plan to go over each event, but rather to touch on a few of them now and others later in the presentation. As noted on this slide, the first request for an exception to the procurement rules was received by the board in May 1997. Following discussion and public input, the board voted in July 1997 to grant its first procurement exception and to approve a one-year pilot program not to exceed 5 charter exceptions from procurement rules. The pilot program's provisions included that the school request the exception from the board, the school be in good standing with the board, and within 60 days of approval, the school notify the board at a public meeting of the procurement process to be used. The board set August 1st, 1998 as the date to review how the program was working. Based on a review of meeting minutes, it appears that the program's pilot status was lifted in September 1997. Unless there are questions, I will continue. Procurement exceptions are granted through the amendment process. The process begins with the charter representative submitting a completed procurement laws exception amendment request, which includes board minutes approving the request for an exception and a policy for procuring goods and services. Upon submission, staff reviews the request to ensure that all required components have been provided and to determine if the submission meets requirements. Additionally, staff assesses whether the charter holder is eligible for the exception. In order to be eligible, the charter holder must meet all of the criteria listed under the second bullet on this slide. If the submitted request does not meet requirements and/or if the charter holder is not eligible, then the request is deemed substantively incomplete and returned. If the submitted request meets requirements and the charter holder is eligible, then the request is placed on the board's next consent agenda. The initial exception process approved by the board required charter holders to notify the board of the procurement processes that they would use in place of the procurement rules. In the absence of guidance for these alternative processes, the board received a variety of submissions ranging from one sentence to several pages. In 2004, the board developed a sample procurement policy. This general and simple statement was created to provide a framework for making and supporting procurement decisions. Its use does not preclude the charter holder from adopting additional procurement-related policies and procedures for its internal use. At this point, I would like to spend some time going through the specific provisions of the board's current sample procurement policy. The first sentence of the board's sample policy requires the charter holder to state that its school will follow accounting policies and procedures that comply with generally accepted accounting principles, or GAAP. Depending on when the charter contract was signed, adherence to GAAP is required by the charter contract or through an amendment to the charter contract, either the ASBCS exception request, procurement exception request, or both. GAAP includes uniform minimum standards for financial accounting and reporting that govern the form and the content of the entity's financial statements. GAAP does not address an entity's procurement practices, but it does require that information related to certain transactions be disclosed in the financial statements. These required disclosures will be discussed in more detail later in the presentation. As you can see from the provision found on this slide, the sample policy does not include defined procurement thresholds. This is due in part to the characteristics of the board's portfolio. Earlier, I mentioned that charter holders' total expenses for fiscal year 2012 range from approximately $310,000 to approximately $24.5 million. In its sample policy, the board could have established hard procurement thresholds for competitive purchasing and bidding, like those that currently exist in the ASBCS and procurement rules. However, under this approach, most of the purchases made by the board's larger schools would have been subject to the policy, while the policy would likely have applied to few, if any, of the purchases made by the board's truly small schools. The board also could have established thresholds based on the charter holder's revenue or ADM. For example, requiring written quotes to be obtained for purchases representing X% of revenues. While such a policy would have applied to purchases made by all of the board's charter schools, it also would have been more complicated for charter schools to implement and to demonstrate their compliance with. In the end, the sample policy was kept simple and required that any procurement of goods and services be made in the best interest of the school after considering several factors. In doing this, the sample policy acknowledges that different charter schools may have different goals when procuring goods and services. For one, it may be price, but for another, it may be quality or the vendor's ability to meet the school's timeframes. The sample policy is also easy to implement and therefore doesn't require a charter holder to divert monetary resources to hire staff dedicated to ensure compliance with its provisions. This was an issue raised by charter schools in 1997 when the board was considering whether to grant its first exception from the school district procurement rules. Today, through technology, charter schools can identify possible vendors, research products and services, and compare prices at any time of the day from almost anywhere. The sample policy's second paragraph addresses purchases of goods and services from members of the governing board, their family members, or from entities in which governing board members or their family members may benefit. Collectively, the individuals and entities mentioned in this provision may also be referred to as related parties. The sample policy intentionally did not establish thresholds, but instead required all purchases involving the specified parties to be subject to this process regardless of amount. The sample policy does not prohibit purchases from related parties, but requires these purchases to be authorized by the governing board after full disclosure of the potential benefits to the charter school and consideration of the factors identified previously, including how the purchase would be in the best interest of the school. The sample policy's last paragraph was added in 2005 following discussions with the Health and Nutrition Unit of the Arizona Department of Education. While the procurement exception has always applied only to state procurement regulations, some charter holders believe that their exception also applied to federal procurement requirements. ADE issued guidance indicating that charter schools participating in federal child nutrition programs must satisfy federal procurement requirements. The board also updated its procurement policy and amendment form. It should be noted that this requirement is applicable for all federal grant funds and not just funds received for child nutrition programs. Up until this point, my presentation has focused primarily on the charter law and various aspects of the board's current procurement exception process. Now I would like to spend some time addressing certain Internal Revenue Service, auditing, and gap requirements before concluding with information regarding the charter school's audits and the board's current audit-related policies and practices. While there is no requirement for a charter holder to obtain federal tax exempt status, many of the board's nonprofit charter holders have chosen to do so. The IRS has established certain requirements for 501c3 organizations. I will briefly address 3 of those requirements now. No part of a 501c3 organization's net income can inure to the benefit of those that control the organization. This is known as the private inurement prohibition. The 501c3 organization must be organized and operated exclusively for exempt purposes by serving the public rather than the private interests. Violation of the prohibition results in the loss of the organization's tax-exempt status. It is my understanding that the private inurement prohibition was rarely used by the IRS, so Congress enacted an intermediate sanction known as the excess benefit transaction. An excess benefit transaction is a transaction in which an economic benefit is provided by a 501c3 organization directly or indirectly to or for the use of a disqualified person, and the value of the economic benefit provided by the organization exceeds the value of consideration received by the organization. Disqualified persons include an individual in a position to exercise substantial influence over the organization's affairs, the individual's family members, or an entity in which the individual or the individual's family members own more than a 35% interest. The last IRS requirement I want to cover is the return of organization exempt from income tax, which is filed by 501c3 organizations. This document is more commonly referred to as the 990. The 990 must be filed annually and provides information to the IRS and public about how the organization operates. The 990 is a 12-page document, not including various additional schedules that the organization may be required to submit. So so the information included under the slide's second bullet represents a small portion of what may be found in the 990. As indicated on the slide, the 990 includes information regarding compensation provided to certain individuals, loans from organizations to certain persons and vice versa, and certain direct and indirect business transactions between the organization and current or former governance and management officials of the organization or their associated businesses or family members. In late November, staff invited all audit firms that audit the board's nonprofit and for-profit charter holders to a meeting in preparation for today's study session. Staff wanted to better understand the standards under which the audits are conducted, as well as certain testing that occurs as part of the audit. In early December, staff met with representatives from 8 audit firms. Combined, these firms will conduct nearly half of the 380 fiscal year 2012 audits. Generally accepted auditing standards establish the guidelines for how financial audits are to be conducted by the auditors. An audit conducted under these standards includes an auditor's opinion on whether the entity's financial statements are presented in accordance with GAAP. You may recall earlier I mentioned that the charter holders must comply with GAAP, which governs the form and content of financial statements. State law requires that charter school audits be conducted under government auditing standards. These standards add additional considerations to generally accepted auditing standards. Among other items, government auditing standards address reporting requirements, including a requirement that the auditor report on the entity's compliance with certain provisions of law, regulations, contracts, and grant agreements. Much of the December meeting with auditors focused on related party transactions. Related parties can include board members, management, family members of board members and management, and entities that these individuals are associated with. Under GAAP, the charter holder is required to disclose information about related party transactions such as financial statements. These transactions may include borrowing between the charter holder and related parties, guarantees provided by the related parties or charter holders, and services received from related parties, even if those services are provided without charge. It is important to note that related party transactions cannot be presumed to be at arm's length. In order to be considered an arm's length transaction, neither of the parties involved may have an interest in the transaction's consequences to the other party. When the charter holder undergoes its annual audit, the auditor is required under generally accepted auditing standards to evaluate the adequacy of the related party disclosures in the charter holder's financial statements. During the charter holder's audit, the auditor must determine the existence of related parties, identify transactions with the related parties, examine these related party transactions, and determine the sufficiency of the transaction's disclosures. In speaking with the auditors, it is the first step, determining the existence of related parties, that is the key step. Certain auditing procedures, including those related to understanding the entity being audited and performing fraud risk assessments, may help the auditor in identifying who the related parties are, but they do not reflect the extent of the audit work conducted. The auditors indicated that to determine the existence of related parties, they inquire of the charter holder, scan the charter holder's ledger, review meeting minutes, and as needed, conduct searches through the Arizona Corporation Commission's business entity website. The goal here being to come up with a complete list of related party transactions. A charter holder's audited financial statements must disclose material related party transactions. The disclosures are required to include the nature of the relationship, a description of the transaction, the dollar amount, and any values due. There is no standard definition for what is material. Because there are qualitative and quantitative aspects, auditor judgment comes into play when determining materiality. As such, different auditors may have different opinions regarding whether something is material or not. In speaking with the auditors, they also indicated that different things could impact whether something is material from year to year for the same client. That said, many of the auditors present specifically stated that they are sensitive to related party transactions, and therefore there is usually more disclosure rather than less unless the related party transaction is truly trivial. Currently, each financial statement audit reporting package received by the board includes the items listed under the first bullet. The financial statements would include the auditor's opinion on whether the charter holder's financial statements are presented in accordance with GAAP. The notes to the charter holder's financial statements would include the related party disclosures. The report on internal control and compliance required by government auditing standards is where the auditor would disclose any findings required by auditing standards. The auditing standards that we've been discussing apply to all charter school audits, regardless of whether the charter holder has been granted a procurement exception or not. The difference shows up with the compliance questionnaires. For charter holders that have received procurement exceptions, the auditor completes either the legal compliance questionnaire or the USFRCS compliance questionnaire, depending on whether the charter holder has received an exception from the USFRCS or not. Currently, the legal and USFRCS compliance questionnaires do not include questions regarding related party transactions or charter holder procurement practices. The remainder of my presentation focuses on what the audits show in regard to related party transactions and the board's current follow-up process for any related party or procurement issues identified through the audits. The information included on this slide focuses on the last 5 completed audit cycles, or fiscal years 2007 through 2011, and is based on my review of more than 1,700 audits during that time period. First, it is important to note that not all charter schools engage in transactions with related parties. Second, related party transactions include 0% interest loans, personal guarantees so that the school can obtain a line of credit or loan from a financial institution, and forgiveness of amounts owed for services provided. Finally, in some cases, the decisions made by charter schools or the way they handle their related party transactions will result in findings being disclosed in the audit. Generally, the findings involve either violations of IRS requirements or weaknesses in the school's control environment. It should be noted that these types of findings show up in audits of charter schools that have and have not received procurement exceptions. This slide includes examples of IRS violations. I believe the issues identified in the last 2 bullets are fairly self-explanatory, but I want to spend a little time on the first issue. When the audit indicates the organization did not have documentation available to support that the fees for services were at fair value, that doesn't mean the organization did not have any documentation to support the transaction. But it does mean the organization did not provide the auditor with documentation showing a method or rationale for how the organization determined the fees to be at fair value. If the IRS were to come in and determine the payments to be at more than fair value, then this would result in the organization having entered into an excess benefit transaction. In this situation, the amount paid to related parties in excess of the fair amount would need to be returned to the organization. If the organization could provide information to the IRS that provides reasonable support for the organization's fair value determination, then the IRS would likely determine that no violation has occurred. Generally, the IRS issues identified in the first and third bullets occur in 1 to 2 audits per cycle. For the 2010 and 2011 audit cycle, staff reviewed approximately 365 audits each year. This slide also includes examples of weaknesses in the school's control environment. I believe the first 2 bullets are fairly self-explanatory, but we'll briefly discuss the last 2. Regarding the third bullet, this finding is connected to the related party disclosures required by GAAP and auditing standards. As you may remember, a charter holder's financial statements must disclose specific information regarding these transactions. Part of the auditor's responsibility includes determining the sufficiency of these disclosures. Therefore, if a charter holder does not have sufficient documentation to support its related party transactions, then the auditor may write up an audit finding. As an example, the fiscal year 2009 audit for one charter holder indicated the charter holder did not prepare sufficient supporting documentation, such as promissory notes and board of directors authorizations for related party cash flow loans. As noted in the 4th bullet, the findings may also involve weaknesses in the school's accounting and disbursement practices. For example, overpayment to a related party or loan repayments to a related party occurring outside of their normal disbursement process. Generally, the control weaknesses identified in the 1st, 3rd, and 4th bullets occur in 1 to 2 audits per cycle. Before moving on, I wanted to provide another example that includes findings from both areas that comes from a charter school's fiscal year 2010 audit. In the area of controls, The audit found that the charter school had paid a related party vendor approximately $5,600 in advance of the services being provided, and it also contracted with both an individual and a company owned by the individual's wife to provide the same services. Further, the audit indicated that the school leased 2 vehicles from the school's chief financial officer at amounts which may be deemed excessive. These examples will be visited shortly when addressing the board's audit follow-up processes. In October 2003, the board developed the audit and compliance questionnaire follow-up matrix to guide staff review of the annual audit reporting packages and staff's follow-up with charter holders on issues identified in those audits. Since your computers are not connected to the internet, a copy of the audit matrix has been included in the folder containing the study session materials. The audit matrix classifies issues identified through the audits into one of 3 categories: minimal impact findings, medium impact findings, and serious impact findings. In July 2008, the audit matrix was amended to address consequences for the second time or third time an issue is identified that the first time required a corrective action plan. In accordance with Arizona Administrative Code R7-5-504, each charter holder receives a letter after the audit has been reviewed. Depending on the impact of the issues identified, the letter may indicate that the charter holder should work towards correcting the issues and that staff will monitor for repeated issues in the next audit. Indicate that the audit noted repeated issues that had not been addressed for the prior year's audit. Require the charter holder to submit a corrective action plan and/or state that the charter holder will be placed on the next board agenda for possible disciplinary action. So now to how the board's administrative rules and audit matrix translate to the issues we've been discussing today. For most IRS issues, the audit letter states that the matter will be referred to the IRS since these issues involve the interpretation of IRS requirements. Staff sends written communication to the IRS regarding the issues that were identified, and then staff monitors subsequent audits. One exception to this has been for IRS issues that involve the charter holder's lack of documentation to support fees for services being at fair value. In these cases, staff has reviewed the next year's audit to determine if the issue is repeated. If a repeated issue is identified, the matter is noted in the charter holder's compliance history. At this time, repeated issues, even if noted over multiple audit years, do not rise to the level of requiring a corrective action plan. For control environment issues, staff requests a corrective action plan. Staff then monitors subsequent audits for a second or third time occurrence. In accordance with the matrix, the second time staff identifies an issue which the first time required a corrective action plan, a hold is placed on expansion-related amendment request. Depending on the sufficiency of the response submitted, the charter holder may be brought to the board for possible disciplinary action. The third time staff identifies the same issue which the first time required a corrective action plan, the issue is considered a serious impact finding, and the charter holder is brought to the board for possible disciplinary action. Currently, issues identified through the procurement compliance questionnaire are monitored for repeated issues in the next year's audit. Earlier, when discussing what the audits show, I provided examples from 2 charter holders' audits, but this time I would like to go over how those issues were handled under the board's current processes. In the fiscal year 2009 example, where insufficient documentation was available, the charter holder was asked to provide copies of documentation formalizing current related party transactions and the school's procedures regarding related party transactions. The response provided by the charter holder stated that all loans had been satisfied as of December 31st, 2009, and that this would be reflected in the 2010 audit. The charter holder also provided its policy should the school need to enter into cash flow loans with related parties in the future. The fiscal year 2010 audit for this charter holder identified the same issue as before and indicated that all related parties' loans had not been satisfied as of December 31st, 2009. The charter holder was asked to provide specific information from its accounting records showing any amounts borrowed from and or repaid to the related parties from July 1st, 2010 to date. Based on its own policies submitted in the prior year, the charter holder was asked to provide for all related party cash flow loans entered into during the period of July 1, 2010 to date, copies of the meeting minutes documenting board member approval and the promissory notes, and finally, the charter holder was asked to provide written confirmation that it had read the board's audit matrix. The charter holder submitted the requested information, and the fiscal year 2011 audit indicated that the issue had been addressed. The second example included multiple control weaknesses and possible violations of IRS requirements identified through the fiscal year 2010 audit of another charter holder. This charter holder was asked to provide a copy of the school policy and/or procedure prohibiting the school from making a payment in advance of the receipt of goods and services, and a copy of the governing board minutes and materials approving the policy or procedure. Also asked to provide an explanation for why the school contracted with both an individual as well as the company owned by the individual's wife to provide the same services. And finally, was asked to provide copies of all applicable meeting minutes and materials where the governing board authorized the contracts mentioned previously after full disclosure of the potential benefits and considerations of the items identified in the school's policy. In this case, the school's policy was the board's procurement policy. Additionally, the charter holder was notified that the matters involving the school contracting with both an individual and a company owned by the individual's wife to provide the same services, and the school leasing 2 vehicles from the school's chief financial officer at amounts which may be deemed excessive would be referred to the IRS. In its response, the charter holder's new management provided a release agreement signed by the individual and the individual's wife, avoiding the consulting agreements they had with the charter holder, as well as letters from these 2 individuals resigning all positions with the charter holder. The minutes provided showed that the charter holder did not comply with its procurement policy. The charter holder also provided a copy of its newly adopted policy regarding advance payment for vendors and the minutes from the meetings during which it was approved. The fiscal year 2011 audit indicated that these issues had been addressed. Before turning this over to Deanna, did you guys have any questions?
Are we done PowerPoint?
We are not done PowerPointing. But we will be brief. So start at the beginning, all right. In preparation for today, I sent an email to the charter listserv and asked them for responses. A couple of things that I addressed specifically. I asked them to provide some examples of how the procurement exception had proven to be beneficial to their operations. And I also asked them to share any policies that they had developed beyond the policy statement in the procurement exception amendment that they thought might model some best practices. Got a tremendous response both in email and phone calls, and had the opportunity to speak with many representatives in person as well. And so I want to share with you a lot of what they had to say. I've captured statements from a variety of submissions, and while these are only a sampling of what I received, and their submissions were as unique as their own charter operations, I believe that the sentiments are the same, regardless of how they were conveyed. And I'm just going to share a couple of examples with you. One of them says, cost-saving and timely procurement activities actually save taxpayer dollars and are guided by policies that stipulate shareable, transparent, and ethical purchasing, as well as full disclosure of potential benefit. Another one says, the procurement exception is one of the main reasons why we exist today and have a successful school. We save considerable funds and are able to make our dollars stretch because local businesses and communities will provide services at a lower cost. And finally, the bond between vendors and buyers is an important one, and a good relationship has been created. It is important not to put them through the ringer each time a new contract comes up. However, this does not mean that we do not, on a regular basis, just make sure that who we are using is in alignment with the market expectations. That can be done without a huge bid process and is just sound business practice. In addition to sharing their opinions about the importance of the procurement exception to their operations, those who responded also provided some examples of how they've saved money or otherwise benefited from having the exception. The benefits, whether they were in securing facilities, maintaining operations, or purchasing classroom supplies, added up to thousands of dollars that can be used to support the operations of the school and their educational programs. I have 2 slides of cost-saving examples, but I'm just going to read a couple of the comments for you. In 2007, we built an addition, which we got 3 bids on because it makes good business sense. Then last year, we needed to make some improvements based on the use of the new space, which cost us around $68,000. It was so nice to be able to go back to the construction company that put up the addition and just have them make the changes without having to go out to bid again. We had developed a relationship, and I know we got a really good deal the second time around. Another one said, we were helped in buying our buildings by our board member who is not a family member. These board members volunteered all of their management hours for free to help us through the process of our build out. We had a lot of changes we needed to make. There was a lot of time down at City working with the inspectors, and we were never billed for that time. The construction was done by the same companies that the board members used to do the pre-build on their own commercial real estate. If we had had to bid out to 3 contractors for this job, then it would have been impossible to get it done in time. And then just one more. A copier rep showed me several options for copiers once. When I said we had an exception to the procurement code and we could purchase off contract, the rep said, well, in that case, I have these models that will cost you half. So it's money, it's time, it's choices, and it all comes back to the flexibility to make purchasing decisions in the best interest of the school upon considering the totality of the circumstances surrounding the procurement, which may include, but not be limited to, price, quality, availability, timeliness, reputation, and prior dealings, just as the board's policy statement requires. In addition to the feedback that we received from individual charter representatives, we also had a response from the Charter Association's Advisory Board Business Committee. And I've provided you with their response here. Specifically, it says, the root of the procurement issue is not sound business practices, but the public perception of related party transactions. The USFRCS procurement guidelines are very restrictive for charter schools and would increase the operating costs, salaries, legal fees, etc., for charter schools and present substantial time delays. We oppose any new restrictions relating to procurement and believe we can address the current issues with tweaking a few processes that currently exist. And they did provide then some suggestions. One would be the additional component to the exception request. The other one would be an additional question to the legal compliance questionnaire. Adding a question to the legal compliance questionnaire is doable, but it doesn't come without a price. If this is something that the board would like the staff to explore, we need to discuss what information you'd actually like us to collect in the question that is asked, and then what the requirements would be if the response were returned as a no. With regard to conflict of interest policies, some of the charter reps provided their conflict of interest policies to us. I went ahead and put together some of the commonalities in those individual conflict of interest statements and have a slide for you here. Specifically, their policies all had in common that they had a definition of an interested person. They also included a duty to disclose and the procedures for that disclosure. And then they also had an annual statement in their policy that said, or a statement in their policy that said they would annually collect a statement of understanding of the conflict of interest policy from each of their board members. And that is the end of the information that we received. Again, we had a great response from the charter representatives. I do want to share that Andrea's presentation included hours and hours over at Archives, listening to those tapes from 1997. And so she has a tremendous amount of background information now, and she has shared that with you. And so we'll open this back up to you now, get some feedback from you. If you want to provide us some direction and some next steps, we do have 2 submitted call to the public at this time, and perhaps we'll get more as we proceed.
Board members, any questions for staff? Seeing none, why don't we do the call of the public?
Is there any additional funds?
Oh, okay.
Let's see.
She's working on it.
Okay, well, we'll get started here. How about John Todd? Welcome.
Good afternoon. For those of you who don't know me, I'm John Todd. I'm a CPA that has audited charter schools since the beginning. I was part of drafting the current language that exists for the exception to the procurement. And I just have a few brief comments. First, please don't overreact to the newspaper articles. Consider how the articles were framed and think about whether we would even be having this meeting if the article said 300 of the schools had no procurement issues. Secondly, I believe, as a father of 3 charter school students, the key issue is academics. And regardless of how the schools spend their money and how people are compensated for doing that, the key for me is whether or not the schools are achieving the academic success that you guys have outlined for them. Third, as the previous presentations have indicated, the charter schools need to be allowed to function. And placing more burdens on them from a procurement standpoint is going to inhibit their ability to function. Small businesses don't typically have procurement policies. And some of the issues that were addressed in the newspaper articles said that the policy wasn't a policy. Well, it was never intended to be policies and procedures. It was crafted based on the Arizona Auditor General's office, who contracts for audit services with various firms. And back in the 90s, they said the only thing that we do to document the award of the contract is to put a statement in the file that says we believe that it's in the best interest of the Auditor General's office to contract with this firm at this price. Simple, done. Finally, I think that there is a concept that's defined in government auditing standards, and that is abuse. Certainly, some of the things that are disclosed in the audit reports for related party transactions could be considered abuse, and I think it would be important for the board to focus on those things rather than to penalize all the schools for the abuse of a few. Thank you for your time.
Thank you. Any questions for Mr. Todd? Next up is Representative Eddie Farnsworth.
Thank you, President Logan. Although I'm not here as a representative, I'm here as a charter operator. And I think someone who's in a unique position, because if I'm not mistaken, I'm the one that requested and received the first exemption. So, and in fact, I think I probably drafted some of the language that you were reading today. May have been tweaked, but certainly totality of the circumstances, things like that, you know, Mr. Logan will verify that that's the way I speak. It's just kind of an issue for me. First of all, I'd like to say thank you for taking on this issue. I think it's important. I'm not offended by the fact that we're looking at this and reviewing what the procedures are. I think that that's valid, and I commend you for doing so. I also commend the staff. I know Deanna and Andrea and others put in a lot of time, and I think that they were thorough in presenting what the current state, historical and the current state of the procurement laws are. What I think that I can offer is maybe a little different perspective. We received our charter. We were one of the first In that very first year, we've been operating now, we're in our 18th year. As I said, I've worked on the language, I've worked on the legislation, I've run the schools for 18 years. I also served I'm an attorney, and I served as a in-house counsel for 12 years. So I have, although I won't proclaim myself to be an expert because I haven't practiced in about 10, I will say that I have some working knowledge with the laws and with the way these things work. So what I want to do is just, if I may, Mr. President, just talk about a little bit about the way I see charter schools. Unfortunately, most of the time, we lose the historical intent of what the legislature wanted charter schools to be. And we start to measure them against government. We start to measure them against district schools and against any other kind of government agency that might exist. When in fact, that was exactly what the legislature was trying to get away from. They were trying to create a system where entrepreneurs and people who are outside of the government practices could come in and run schools and create this competitive environment and do it with some flexibility and some knowledge that they bring from being outside of government, and then see if we can make this a better system. And I think for the most case that has worked. It is very clear in the statute in 15183B, the sponsor of a charter school may contract with a public body, private person, or private organization for the purpose of establishing a charter school pursuant to this article. 99% of the charter school operators are private corporations. They are not government bodies. They are not government entities in any way. They contract with your body, and now I think the vast majority are with this board, but used to be with school districts or the state Department of Education. We are contractors. Some not-for-profit, some for-profit, but we are private corporations that contract with the government to provide a service, and that service happens to be education. No different than anyone else who is a contractor and provides health care or builds roads. Those roads are public roads, but the person who built them is more than likely a private contractor. That's what we are. Now, go back historically to what we were facing, and in the early years, the legislature wanted there to be accountability, so they created the requirement to follow USFRs and reporting, but they also knew that there would be an opportunity to get outside of those constraints, and that's why the language was in there that we could get exemptions. That's why I applied for it in 1997. So what has happened is we recognize that we now can go to a bank or we can go to a vendor and we can give them our financials, and it's not in some government cryptic code, but it's in the same format under GAAP that everybody else deals with in this world. And we can deal with them, and as a result, we've seen charter schools expand and do very, very well. And part of that is because when we deal with vendors or banks or lenders, they can understand what we're talking about because it's in their language. To do it the other way was very cumbersome. You had to find somebody in government that knew how to apply USFRs, and a move to GAAP and an exemption from procurement allowed us to deal in the real private sector world and to get the benefit of that real private sector world. That's what you heard up there when Deanna read those comments. Now, where I think that I have a little bit of a concern is that we're trying to fix something that already is fixed. Meaning that even the recommendations, and this isn't against Deanna or anybody else, but when you look at the court, if you take what they said, that 99% of charter schools are owned and operated by corporations, whether not-for-profit or for-profit, then you have to understand that Title 10 comes into play. We are subject to the corporate laws that are under Title 10. And those are that every corporation has to have a corporate board. Every corporation under 10801, the ultimate authority is with the corporate board. So the responsibility to make sure that those things are being done appropriately within the contract and within the law is the purview of the corporate board. The conflict of interest statutes, which are 10-388, 3860 et al., deals with these conflict of interest issues. And there's already a requirement that if a board member has a conflict of interest, they have to disclose that to the other board members. Now those board members, who all have a fiduciary responsibility to look after the best interest of the corporation, have to decide whether that that disclosure, if there's a conflict of interest, whether that disclosure is still in the best interest of the school or the corporation. And in that case would be, for example, if you had somebody on the board that had a roofing company and was willing to come in and say, look, I'll fix all the roofs, but I won't charge you anything except actual costs. Well, that corporation is going to save money. And though there is a conflict of interest, it inures to the benefit of the organization. So it's absurd to think that board should say we shouldn't accept that. So that's what this has allowed us to do. So in my mind, the question is, do we have a flaw in the policy, or is it simply that we have some schools and some board members that are not living up to the policies that exist, whether they be IRS requirements or whether they be statutory requirements? That's what we have to look at. I say that the presentation you just received was very clear in saying we have everything in place to deal with the procurement exemptions and to require compliance. That doesn't mean, though, that we're not going to have people who will be out of compliance. We have laws on the books ad nauseum, and yet we have people that violate the law all the time. The answer isn't to pass more laws. The answer is to get compliance with the current laws. So I commend the board and I commend staff for looking at this and saying, the policies are in place, they are reasonable policies, they have inured to the benefit of the charter schools, and the charter schools are going to look after their best interest. And why is that? Because they are corporations with a personal interest, they provide an education, they have people that come, they get paid, and though some people think this is a dirty word, the 7.8% that are for-profit actually make a profit doing it. And I'm one of those that doesn't believe that's a dirty word. As long as they can provide the services and comply, and they get the people that want to be there and they can make a profit, I don't care. So the question is, are they compliant? That's what this comes down to. Because at the end of the day, all of these corporations are saying, I want to save money so that my corporation can be successful. That's why they're asking themselves, how do we save money? And the procurement exemption does that. All of the standards are in place. It doesn't need to be changed, but we do have to be diligent in making sure that people are complying with the standards and the laws. And I commend you for doing that. I would request that you don't make any changes, but that you continue to do what you've been doing, identify those people who are out of compliance, and then bring them into compliance. That's really the important piece. With that, Mr. President, I appreciate it, and I'd stand for any questions if you have any.
Board members, any questions for Mr. Farndorf?
Mr. President, so in just more about just making sure getting the facts out. So regardless of your procurement practices, if you fell under a procurement policy or not, does that change how the school is funded? Because there's a concept about taking care of the taxpayers, and to a certain view, that is making sure you're educating the students, right? So regardless of your procurement process, the question is, does your procurement process affect how you're funded?
Well, Mr. President and Mr. Butler, I appreciate that. The answer, at least theoretically, is no. I mean, if you go far askew of the policies, then yes, you could have a 10% withholding and all those, but I don't think that's what you're asking. The funding comes in. But see, again, I take a little different approach. The statute is very clear in saying that the charter schools own the assets. What is my incentive to follow procurement and to get the best deal I can get? Number one, I save money. It's my money. Contrary to what people want to say, the state contracts with me, and when I earn it, it transmutes to my money. No different than when Deanna gets paid a paycheck right out of the state coffers, and she's earned it, it transmutes and becomes private. It's her money. Or if she goes and buys something, it transmutes back to the government through sales tax. So we have incentives, number one, to be in a competitive model where we have to operate successfully against competitors, but we also have the incentive because we're looking after the best interest of the corporation. So the answer is no, but I will take a step farther, which is we are incentivized to get the best price that we can. And in fact, in my school, we go way beyond what is expected, because I look at the prices, and even if I have 3 bids and I don't think the prices are low enough, I'll tell my assistant, get 2 more bids. I think these are too high. Get them down. And that's what you heard from the statements that were there. So no, it doesn't change, but a change in policy could affect the finances and money that we have that are available.
Board members, other questions for Mr. Farnborough? Seeing none, thank you. Thanks for
Thank
taking
you,
the time
sir.
to come down.
Members of the board, appreciate it. Thank you again, staff. Great presentation.
The last one I have is Jody Johnson. Jody, hi. Thanks for being here.
Thank you. I sat on the subcommittee with the Charter School Association Advisory Council as we discussed the issue, and Deanna was wonderful in presenting what we had come up with. I think the one thing that I wanted to add is that we were, a big part of our discussion said that on the 990s, this issue should be taken care of with the related transaction parties. And the presentation that Deanna's group just gave very clearly said that that gets reported back to the IRS. That was a piece we didn't have. And so based on that piece, that already gets reported by District Board for Charter Schools to the IRS, we would say don't add anything to the compliance questionnaire. That was based on us not having complete information on the process that happens up at this end, just knowing what happens down at our end, and saying, hey, the IRS is really who should be dealing with the related transaction. And that's it.
Perfect. Board members, any questions for? Yeah, okay. Board members and Deanna, that concludes our agenda. I don't know if there was any further discussion today. We obviously have a meeting next Monday with our regular agenda, not a study session. But board members, I don't know if there's anything else anyone wanted to discuss today relative to the agenda. Yeah.
I just wanted to also commend staff on the presentation, Andrea, that you did. That was really remarkable. I know how much work that went into that, and it was a great, I think, educational tool to really dig into this and see what goes on in it. And I've had a chance as a parent of two girls that are in charter schools. I've had a chance to talk to a couple of those charter operators, and I just like to say, in my kind of private investigation, of this, kind of looking at it to see, get kind of all sides of it. Many of the statements that were, on here were echoed by the charter operators that I talked to, and they all have, echoed the statements of, don't hamstring us with more regulations, don't, the bad actors that are out there are going to be bad actors in any business that there is, and there are rules in place, as we saw in the presentation, that take care of that. And I think, to echo Mr. Farnsworth's comments, let's get the ones that are not in compliance, and treat the ones that are the bad actors as bad actors, and not add more regulation or more paperwork to the folks that are doing it right. So I think that was the general intent of what the charter movement was, and I support that.
And I'd like to, Mr. President, also comment, since I had to sit through the school district procurement code rewrite meeting on Monday morning, procurement week, I completely understand why anyone would not want to have to follow all that stuff. For me, I feel like we actually have more ability to catch the bad actor with the charter schools actually than with the school districts. If the school district is not compliant with their audit, we don't withhold 10%. We only withhold money from them if there's an adjustment in the budget for an ADM audit or something like that. We don't, we can't close the school down like we can here. We can't, we have much more of an enforcement arm with our charter schools than we actually do with the school districts. And they have just as many audit findings as a charter. I mean, they're people. People make mistakes. They have bad judgment. Whatever happens, just when you get a large group, there's always going to be something that happens with somebody. And sometimes we actually hold the charter schools to a higher standard because we give them so much flexibility with the money. And I think that we actually hold them to a higher standard with the accounting and auditing stuff. So, all I'm saying, thanks, Deanna. I know that couldn't have been easy to do all that research on that.
Andrea.
Yeah, Andrea.
Sorry,
Deanna, Andrea, and
Yeah, Ms. Butler.
President Logan, I'd follow the comments behind Kathy and Stacy. When you think about it, And my question to Mr. Farnsworth is, the funding doesn't change, right? And if you consider the schools, we'll talk about the for-profit, there is economical risk that those schools bring to bear, right? It's their capital, and so there's a return on that. And you could argue that there's a transfer of some of that risk from the government to those individuals because they are putting up their own capital related to it, they're taking the risk related to the properties, et cetera. But my question was focused on the fact that regardless of how the procurement happens, it doesn't change the funding because each student is funded at that amount. And what we're doing as a charter authorizing body is to put it in the hands of individuals who believe that they can operate in that market based on how they're funded. And we expect them to deliver academics, right? And so, and I feel really good on what this board has done on measuring academics. And I also feel good on what this board has done recently as we look to financial performance, which was done here in the past period of time. So I'd echo Stacy's. There's hammers related to noncompliance, and there's also increased accountability. So I'm in agreement with my counterparts as on their statements related to the policy.
Board members, any other comments, questions, thoughts before we adjourn for today?
Mr. President, so it was presented today, we had deferred some voting on a couple of these items at our last meeting. Do we know, are those on the agenda for the next meeting to have those resurface?
They are not, but they can be.
Okay, well, Mr. President, I would move based on our discussion today that we make sure those items that we deferred last meeting, to make sure that those are at least on the agenda, even if it's perhaps as a separate item. But based on the feedback I'm hearing from our board, I don't see why we wouldn't bring those items back onto that agenda unless anyone has other thoughts. And at that point, we have a discussion on whether or not we want to approve or not. But I think we'd be remiss in not including those based on our discussion on us, everything follows law. And I don't know that there's anything that's occurred yet that would prevent us from at least discussing those items.
Mr. President, unless there would be some specific reason or additional information or additional discussion that you might have on this at a later meeting that would direct staff to collect additional information or do something different, we can simply put those exceptions back on the consent agenda as they currently exist. And I would defer to Kim, but I don't know that it would even take a motion for me to do that. I can just revise the currently posted agenda to reflect those additions.
What are you guys saying?
I mean, it was tabled. I was assuming that they would be on the January agenda.
Okay. Anything else, board members, for today? All right, we'll see everybody on Monday. We're adjourned.
Thank you.